So this is the very first webinar of our SEN information week. And what we are aiming to do is to deal with certain topics that we have found have been of particular interest to parents. So this webinar is very much aimed at parents or other relatives of children with special educational needs. So you should all have seen the housekeeping. Just please keep your microphones off during this recording. If you have any questions, put them in the chat box, and one of my colleagues will keep an eye on them, and she will read out the questions without identifying names or of parents or children, and we'll try and deal with it at the end. The aim is that this will last until about 11 o'clock, and then we'll have questions after that. As I say, it's being recorded, but the part that's going to be recorded will be the presentation. So what are we going to cover? We're going to cover understanding the importance of phased transfers and timescales, different options, mainstream versus special school, how to obtain an independent school, what is meant by an independent school, education other than at school, which often means that the child is receiving education at home, understanding what is meant by parental preference, common placement arguments, what if the school says it's full, understanding the cost argument, and what settlement options might there be. So beginning at the beginning, as they say, what do we mean by Section I? Section I is the name and type of school, so it can be a maintained nursery, post-16 institution or other institution to be attended by the child or young person. And it can include an independent school or college. So you can have nurseries, you can have primary schools. Some parts of the country still have a three-tier system. So they have lower school, middle school, upper school. You can have secondary schools. You can have independent special schools. You can have maintained special schools. You can have independent mainstream schools. And you can have post-16 colleges, post-16s, special schools, post-16 independent schools. So mainstream versus special school. If a request for a particular school, if there's a request for a particular school, then the local authority should comply and name it in the EHC plan, unless it would be unsuitable for the age, ability, aptitude, or SEN of the child or young person, or the attendance of the child or young person there would be incompatible with the efficient education of others or the efficient use of resources. So that is the law, and that is what a local authority would need to show if you request a school and they refuse. They need to show A or B. B, realistically, is all about costs. That's what the local authority will say. Inefficient use of resources means that your option costs more. Do not be put off by what the local authority says. They will say they're not driven by costs, but they are, and it's becoming increasingly difficult with local authorities, particularly during this pandemic, where local authorities' budgets are being squeezed. So a local authority may say mainstream would be incompatible with the education of others, but they need to show that there were no reasonable steps that could be taken to prevent that incompatibility. Now, reasonable steps can include a one-to-one support throughout the day. They can include all sorts of things. I remember one case where a school suggested that the school wanted and requested by parents was unsuitable because they thought this was a primary school. The child could climb over the school fence and escape. We then looked into the cost of, I don't know quite what you call it, but it's non-climbing paint to put on the fence, whereby children or anybody else wanted to climb a fence can't claim. Anti-climbing paint, I think it is. And it is not that expensive. So that was a reasonable step that a local authority could do. If a young if a young person, for example, was not toilet trained independently and needed their own separate changing area, in most primary schools, a room can be found and somebody can be trained to carry out the toileting and changing of that young person. But that can be something that a local authority or school might say was incompatible. A school might say they don't have an area where or a room where the young person, if they need it, can go off and have a cool down period if that's what that young person needs. Again, that can be pretty difficult to show and justify. So if a local authority says that a school is unsuitable for the age, ability, aptitude of the SEN child or young person, do not be put off. And look at what it is that the school or a local authority say cannot be provided, and see how it could be provided. There are all sorts of things that a school or a local authority can put in place so that the school can become suitable for your young person. There's no right. So parents have the right to request that the local authority consults with any school of your choosing, irrespective of type. So local authorities will sometimes say, oh, that's an independent school, we're not going to consult with it. Don't be put off with that by that. Say you want them to consult. Local authorities will sometimes say, it's an out-of-county school, we're not going to do that. Again, don't be put off. Any school consulted has 15 days, 15 working days, so in essence, that is 3 weeks, to provide a response. You do get into difficulties with school holidays over this, but basically schools should come back quickly and promptly. So any placement which is considered parental preference, and if you're requesting it, should be formally consulted by the local authority. So the local authority should consult. Sometimes schools will say that they do not feel they can meet a child or young person's needs. The local authority must name the parental preference unless, as we've already said, the school is unsuitable or the attendance requested school will be incompatible with provision of efficient education of others or efficient use of resources. So the efficient use of resources is very much linked to the cost of the placement versus the local authority's choice. Just because what you or a parent seeks is more expensive than the local authority doesn't mean to say that the local authority should not name it. Now, what should you do if a school is full? This sometimes happens with maintained special schools. So if you want, and in certain parts of the country, there is very much a shortage. I'm going to pause there a minute. Somebody has their microphone on. Could they please turn it off? Could everybody please turn the microphone off? Thank you. So what should you do if the school is full? If it's, for example, a maintained special school, and in certain parts of the country, there is a shortage of special schools. And therefore, if you are seeking a special school, what can you do? Even if a school says it's full, if it is a maintained school, that is one run by the local authority, whether it be maintained mainstream or maintained special school, or it's, if I put it this way, a state school, a tribunal can still order that a child or young person attend that school. Now, when you're talking about special schools usually have much smaller class sizes often between 6 and 12. It varies depending on the locality, and it depends on the type of school. It is very difficult for a school or local authority to justify to a special needs tribunal that your child should not be given a place. So if you have a special school that usually has 8 in the class, and the school or local authority are saying they can't have 9 in the class, they are going to find it very, very difficult to justify. And so you need to be asking in those sorts of situations, I would visit the school, have a look, does your child fit in with that peer group in that class? You often, and it does vary, but often special schools.
So let's start. We're going to start at 10 this time and see if you.
Sorry, could everybody please turn their microphones off? So if you have a special school and it has, say, a class size of 8, and you look at that class, often there can clearly be space for one more. If it's a mainstream school, I'm not going to talk about infant class sizes because that argument is slightly complex, but it does still apply that if you can always ask for one more, but it does very much depend when you're talking about reception year 1 and 2. You can still get a place there, but obviously with infant class sizes, that's slightly more trickier. But basically, if you have a mainstream school or you have a special school, even if it says it's full and it doesn't want to go over numbers, do not be put off, because you need to look at and question whether one more person could be added to that. Certainly, having worked in this area for about 25 years, I struggle to think of any case where a parent wanted a special school, the local authority or school said special school's full, and we didn't get, or that parent didn't get a space, either because the local authority and school then gave in, or a tribunal would order it. You would need to be looking at other things around the school and how children move around the school to make sure that one further person wouldn't cause a problem. But it's difficult to see, given special schools are often quite small, that one further pupil would cause such problems that they shouldn't be admitted. And of course, if that special school that you want is the only one within reasonable travel distance, and reasonable travel distance is anything up to an hour, but generally no more, depending on age, obviously, of young person or child, then you've got even stronger arguments. So, and what is an independent school, and how can you obtain an independent school? So an independent school is a fee-paying school, which can either be independent mainstream or independent special school. So around the country, there are a large number of independent special schools. They can be independent special schools that specialise in children with a diagnosis of autism, with a diagnosis of severe dyslexia, with a diagnosis of cerebral palsy, with a diagnosis of emotional behavioural problems. Some independent special schools specialise in having what might be called a therapeutic environment, and that might be something that your child or young person requires. You also have independent mainstream schools, and most cities and towns will have an independent mainstream school, which have very small class sizes generally. Now, if an independent school says they're unable to offer a place, either because they're full or because they consider they can't meet needs, then you can't appeal for a place there, because independent schools are by their nature independent, and they can do, if they decide they are a business, as it were, that's what they are. You can't force the issue. You might try and persuade them and say, well, actually, you think your child would fit in there and they've misunderstood, or something like that. But really, you are limited on what you can do if it's an independent school. Now, if you have a child, and it really tends to work more for primary schools, where you have a young person child in a mainstream primary school with a class size of 30 and maybe a one-to-one TA, often that can be too noisy, too busy, too overwhelming. And therefore, some parents will look at independent mainstream schools where it can be much smaller in size, and the class sizes might only be between 8 and 15, 16. And in the independent mainstream school, that child might not need the one-to-one. So sometimes, not in every case, I just mention it, an independent, that's a private mainstream school, may be cheaper than a mainstream state school. And I'll explain why. If you have a child in primary school and they need one-to-one support throughout the day, and they are somewhat overwhelmed by the noise, the busyness of the classroom, the cost of that one-to-one might be in the region of approximately £15,000, taking all the costs to the local authority. A lot of mainstream primary schools, the annual fees are less than that, so they will be cheaper. And if your child is in a mainstream independent school, they may not need the one-to-one support, because the class sizes are smaller and the school itself is smaller and they are less overwhelmed. This is only for particular cases, but I'm giving you the example of where sometimes independent schools can be cheaper than what the local authority are looking at. The local authority, some local authorities have tried this, completely unlawful, that they say we can't name an independent mainstream school because we have to look at, we have to try and place children in the state system. That's not actually the law. That's not the process you have to go through. So don't be put off by that. I'm going to talk a bit about education otherwise, and this is really sort of in a nutshell, is education where the parent can arrange and perhaps have a personal budget for making the provision of education at home. Some parents may want education otherwise if they want to run a home ABA program, and they will use the budget from the local authority to provide ABA if their child is autistic. I'm not going to sort of go into detail about ABA today, that's for another day, but that might come under education otherwise. So a local authority in England, and I'm going to pause there for a minute, I probably should have said this at the beginning, the law is slightly different in England and Wales. The current system of special educational needs in Wales is pretty much a system that was in England prior to 2014. So, and it's not too dissimilar, but there are differences between England and Wales, and there's going to be some bigger differences because Wales this year is moving to another system. If you're not in Wales, they are statements, which is what was in England. In England, we have education and healthcare plans, and much of what I'm talking about is education and healthcare plans. I'm talking about section I in education and healthcare plans, but if there are any parents who live in Wales, the principles that I'm saying about education and healthcare plans in section I very much apply to statements, section 4. So the principles are there, the law is slightly different, but the principles are pretty much there. So a local authority in England may arrange for any special educational provision that it has decided is necessary for a child or young person for whom it is responsible to be made otherwise than in a school or post-16 institution, or a place at which relevant early years education is provided. An authority may do so only if it is satisfied that it would be inappropriate for the provision to be made in a school or post-16 institution or at such a place. Before doing so, the authority must consult the child's parent or young person. So there are many cases where, for lots of reasons, it may be that a child or young person has significant behavioural issues which make it impossible or very difficult for the child to be in a school setting for a period of time. It may be, and this can be appropriate given we're in the pandemic, that a child may have significant health issues which make it very difficult and could put that child at significant risk if they were in a school environment. It may be that a child or young person has significant anxiety issues that make it very difficult for them to get through the school gate. And that can be applicable in many cases. And severe anxiety in attending school doesn't just apply to nursery up to 16. It can apply to post 16. So, for example, a 17, 18, 19-year-old might well have severe anxiety, and part of their education otherwise might be a package involving a mentor coming to the house and perhaps every day walking with that young person to the end of the road, or starting small and building up, and other education provision as well. So education otherwise has a really, really big remit and can include all sorts of things for that child or young person. So the local authority must decide if it is necessary to educate a child or young person other than in a school or post-16 institution. But what is necessary is usually considered in terms of whether it is inappropriate for provision to be made in school or post-16 institution. What is inappropriate depends on the facts. A child's anxiety may lead for it to be inappropriate for provision to be made at school. Another sort of circumstance where it might be inappropriate is where a young person suffers with chronic fatigue. They can't get up and be in school for 9 o'clock every day. Sometimes they don't, they're only ready for learning at 2 o'clock in the afternoon. So they need education otherwise. They need some online lessons, which of course online now lots of children are having. So that there really can be a wide range of circumstances where a child or young person, it is inappropriate for provision to be made at school. Any approved home tuition is not put into section I. So in such a case, the requirement to specify a type of school in section I remains, but can be met by specifying the type of school, which is the ultimate aim to become appropriate for the child, or where part of the overall package is at a school, that type of school. That's a bit complicated, but in essence, what it means is there's been case law on this that says you can't say education otherwise in section I. So what you might say is that it's hoped that this young person might attend, for example, a special school in the future, but you can't say, or you say the type of school you hope that child or young person might attend, but you can't say education otherwise in section I. So education otherwise, if you're looking for a package of education otherwise, you need a fully broken down cost table. You need a proposed timetable for the 5-day provision. And you need evidence that no school-based placement will be suitable to meet needs. Now, what this means is that you as parents become pretty much accountants. You draw up a timetable and you work out. So it might be, for example, on Monday morning, you have an occupational therapy. Therapist go in and does 1 hour, and that might be sensory integration. Now, that might be followed by an English lesson for 1 hour with an English tutor, and that might be followed by some music therapy. Then you might have some outdoor activity, followed perhaps by an hour of speech and language therapy, followed by some rebound therapy. What you need to do is to set out your 5 days Monday to Friday, set out what you're going to do roughly in the timetable and set out what the cost of that is per week. You really have to provide quite a bit of evidence there. What you don't have to do is to stick religiously to that timetable, but you need to show that you're planning the week and that you can justify the cost you're seeking for a budget. If it was a case of a young person who had chronic fatigue syndrome, for example, and wanted online lessons, then you wouldn't need the timetable, but you'd need some evidence of what the cost of that would be. So all parents need to be aware of phased transfer timescales. So these are circumstances in which a local authority must review an EHC plan. The local authority must review and amend, where necessary, the child or young person's EHC plan before the 31st of March in the calendar year of the child or young person's transfer from secondary school to a post-16 institution. So if your child or young person is moving post-16, then you must have an amended EHCP by the 31st of March. If by the 1st of April, the local authority has not issued it, then they are in breach of their statutory responsibility and you need to take action immediately. Why you need to take action immediately, I will come on to in a minute. If you are looking, if you are have an 18-year-old, 19-year-old, and you are looking to go to perhaps a specialist college post-18, post-19, of which there are some, and of course this afternoon we're going to be talking about post-16 transfers, then you need that amended EHCP by the 31st of March. Now, if you are in a 3-tier system, so your child is moving from lower school to middle school, or middle school to upper school, or you're moving from primary school to secondary school, so this is the end of year 6, then it's not quite Valentine's Day, but it's the 15th of February is the date that you need to mark in your calendar. And that is the date of that you must have the amended EHCP. So anybody that is listening today, anybody that is listening to this webinar, if you have a child that's going to be transferring, we are at the beginning of February, you should have had the annual review to talk about the phased transfer. You should have had the draft EHCP from your local authority. You need the final EHCP by the 15th of February. I think some people might be joining now. Can you please turn your cameras off and please turn off your microphones? Thank you. So it's important you have them, the final EHCP by those dates, and you need to, in some cases, every year we come across parents of children who are having a phased transfer and do not receive the final amended EHCP until July or August, which that young child or young person is meant to be transferring to then either secondary school or post-16 institution in September the 1st, and by the local authority delaying and issuing the amended EHCP, that can delay an appeal and delay that young person starting school or post-16 institution at the beginning of September. We are still dealing with young people's transitions, which should have, the tribunals are still dealing with some cases of children, young people who should have started a new institution in September the 1st, 2020, and the appeals process is still being gone through now. So that child or young person has been out of education since the beginning of September. So you need, the moral of the story, you need to be on the back of the local authority, you need to be prodding them, and you need to take action if they do not give you those amended EHCPs by those dates. Because it will cause problems further down the line. So, and this is where the problem, this is what the problem is. The current timescale for obtaining a hearing date is 5 to 6 months, and it can be longer at different times of the year. If you're looking for a September placement, for example, in September 2021, and the local authority do not have the phased transfer review before the end of February, it is unlikely, in the event the local authority do not agree to your choice of placement, that you would obtain a hearing date before September 2021. If you're this is further explanation as to why timelines are so vital. If your phased transfer of annual review is, for example, 22nd of February 21, the local authority then have 4 weeks to confirm it will amend the plan, which takes you to the 26th of March. If the local authority agrees to amend the EHC plan, they have 8 weeks to issue the proposed amended EHC plan, which takes you to the 21st of May. You then have 2 weeks to respond, which means the earliest they will issue a final amended EHCP, giving you right of appeal, is the 4th of June 2020. An appeal lodged in June might well not be listed until December or January the following year. So hopefully everybody's picked up that it's really, really important that if you're at a phase transfer, you make sure that you have your annual review early and that you make sure the local authority issue the amended EHCP on time. So common placement issues. If the local authority are suggesting a provision which you do not agree with, then you need to identify all of the reasons why the local authority provision will not meet a child or young person's needs. Now, this can include class size or peer group. Quite often, local authorities will say, well, there's a special school down the road, child can go there. But look carefully, look at whether the local authority's suggested special school can actually meet your child's needs. For example, a case of a child who is non-verbal, non-mobile, being put in a, what if I might call it, a generic special school in a class where all the other children are very much mobile, probably may not be an appropriate placement. You need an appropriate peer group. You also may need access to speech and language therapy on site or occupational therapy on site. Often with special schools, they buy in, if I put it this way, or local authority special schools, they'll buy in occupational therapy, they will buy in speech and language therapy. Whereas independent special schools will often have those, this isn't always the case, but they will often have the therapists on site who will be going in and out of the classroom, so that rather than going once a month and the program that they've given the month before not working, it can be adjusted immediately if the program isn't working. And if you have a child or young person who very much needs speech and language therapy or occupational therapy, that might be an issue. Other issues might be, for example, the local authority suggests a special school where most of the children have mobility issues. I know that there was one school, a local authority proposing for a child that had no mobility issues, and they could, because they didn't really have an appropriate peer group, and if I put it this way, a lot of the open spaces around the school were pretty much cluttered with mobility aids, making it difficult for that young person to get around because they did not have mobility issues. It was a completely inappropriate placement. There can be all sorts of reasons why what the local authority suggests cannot meet needs, and you need to make a good list of them. Always look carefully at costs. The local authority will often come in with costs issues, but look at what they're actually saying. Local authorities, if your school is further away from your home than that's suggested by the local authority might well say the cost of a taxi makes it unviable. But look, the cost of a taxi that local authorities put forward is, in my view, often insane. so look carefully at what the costs are that are going to be suggested by the local authority. But sometimes if the school you want is further away, it's actually the transport which can, if you like, take it in or out. So just be careful about how the local authority calculates costs. So understanding the cost argument, where parents and local authorities both prefer a maintained special school and the parental school incurs additional transport costs, this is where it can get complicated. Sometimes the case comes down to transport. So the stages to consider are: the parental school should be named. If the additional cost is not incompatible with the provision of efficient resources, or such inefficiency is outweighed by educational benefit. So sometimes you can argue that actually this child it might be slightly more on the transport costs, but actually this child or young person is going to get such greater educational benefit that the cost is worthwhile. So your school should be named. If there is no duty to name the parental school, the tribunal will determine whether the extra transport costs are unreasonable. Is it unreasonable public expenditure? If the tribunal consider that extra cost is not unreasonable, then the parental school should be named. I will come on to what's extra cost in a minute, but basically, if the additional cost of the parental choice of school, I'm talking about transport only here, is not that great, then then the local authority and indeed a tribunal would go with parental choice. My rule of thumb, and I'll come on to it in slightly more detail in a minute, my rule of thumb is if the parental choice is up to about 5,000 more a year, the parental choice should be named, and the local authority should go with parental choice. So it's not just that the parental choice should be 1 penny less than the local authority's choice, because parental preference has a bit of a weight to it. So if it's a bit more, 1,000 or 2 more a year to transport to parental preference school, then the local authority and the tribunal will go with that generally. So if the costs are costs are unreasonable on the basis that both schools can meet needs, but parents still want their choice, but the transport costs are that much more, then both schools can be named in the EHCP or indeed in the statement if you're in Wales, but there will be a little caveat saying it's subject to the parents paying the transport costs. Of course, there can be a slightly different argument. If let's just say the cost of placement of both schools is the same, but cost of transport to parent school is 20,000 and it's 10,000 to local authority school, you might argue, let the local authority pay you £10,000 towards your mileage and travel costs to get to your school of choice. But often local authorities may refuse to even do that. But in my view, there is no reason why, when you're trying to negotiate with local authority, if what they're proposing would cost £10,000 and yours is £20,000, well, why don't they simply pay you the difference by way of a mileage allowance? Now, that can be simplifying matters a bit, but you can see the argument. If transport or the parental choice is a huge chunk more than the local authority's choice, then it may be you need to consider whether you'd be willing to provide transport or not. Where a parent and local authority both prefer maintained special schools and the parental school incurs additional transport costs, you can agree to paying the transport costs, which I've just said, sorry. So in deciding on the balance between extra costs and extra benefits, all benefits, including health, social, other benefits, not just educational benefits arising from the extra cost, must be taken into account. What are unreasonable costs? I've already said that my rule of thumb tends to be about a £5,000 difference, but in one case, it was decided that the extra cost was not necessarily unreasonable, in which the local authority package would have cost 5,641 and the parental package 12,286. So this was a difference of nearly £7,000 per annum, wasn't necessarily unreasonable. In another case, £4,000 was not necessarily unreasonable, given the benefits of parental preference school. In other cases, a 71,000 difference was not dismissed as inevitably unreasonable if you can show what the benefits of the parental school are to the local authorities. In other cases, even fairly modest additional sums required to place a child in the parentally preferred school may prevent the tribunal from naming it unless there is clear explanation as to the additional benefits to be derived from parental preference. So it can depend on the local authority, it can depend on the tribunal. But what I'm saying is don't be put off just because your school is a bit more expensive than the local authorities. Now, if you're desperately wanting your particular choice of school, you can try and reach a settlement or an agreement with the local authority. And I've already mentioned it could be that you agree to pay transport, the local authority pays the school fees. It could be you agree to pay transport, local authority pays a proportion of school fees, and you pay a proportion of school fees if it's an independent school. So sometimes local authorities will say, look, we'll pay the school fees, but we're only going to pay up to 20,000 a year, or parents might say, okay, we'll contribute £5,000 a year because it's worth it to have that child in that school and not have to go to contested tribunal hearing. Could be parents agree to pay transport and the cost of a one-to-one and the local authority pay all the school fees. Or the local authority could agree to pay a budget towards an education otherwise at school. So there are various options there, and it can be a bit of negotiating with the local authority. Some parents desperately very much do not want to have to deal with a contested tribunal hearing and will try and negotiate and discuss with local authorities. Some local authorities are very keen to reach settlements with parents and will enter into negotiations and discussions. Other local authorities will not. So it just depends on the circumstances. So we're slightly earlier. That has been a pretty, that has been a pretty fast canter through Section I. If you're in Wales, it would be part 4 of the statement, and some of the issues which come up over placement. In many cases where a parent seeks a particular school, they will have investigated that school quite thoroughly and have the view that that school can meet needs. They will have looked at the local authority offer and decided it can't meet needs. What you need to do is to set out clearly why the local authority school cannot meet needs, because if local authority school cannot meet needs, the cost becomes irrelevant. So the first stage of any discussion is, can local authority school meet needs? If not, parental preference prevails. If the local authority school can meet needs, then you look at the costs issue. So although I've dwelled a bit on the cost issue because it is complicated and you need to understand it in some cases, in many cases, the local authority suggested school simply is inadequate or cannot meet your child's needs. Therefore, in those cases, the costs will not become relevant. So shall we now turn to any questions? Emma, are you able to?
Yes, so the first question we have for you is, why can an LA name a placement that a parent hasn't chosen, and when that placement says they can't meet need? So when can an LA name a placement that a parent hasn't chosen when that placement says they can't meet need?
Well, that's you know, that's a local authority, frankly, that's not behaving reasonably. So the local authority should not have named that school because you have evidence that that school has said that they cannot meet your child's needs. So you definitely need to lodge an appeal against that decision. That is what I would call very much an unreasonable decision. Sometimes local authorities will put pressure on schools to admit, particularly if it's a maintained school. A local authority can direct a school to admit pupils, even though the school itself feels they cannot meet needs. In those, if you think that the school has, well, the person who's asked this question clearly knows that the school have indicated they cannot meet needs, so they have evidence of that. No tribunal in the world is going to name a school where the school has said they cannot meet needs, so the local authority would need to back down. So in that case, the parent should lodge an immediate appeal against that, and if reasonable local authority, they should give in prior to any tribunal hearing. I mean, a local authority is going nowhere there, absolutely nowhere. It's completely unreasonable. You might also want to request from the, sorry, you might also want to make a request for copies under GDPR of all the correspondence between the school and the local authority, because that might give you further evidence that the school have clearly indicated they cannot meet needs. I would expect in that case the local authority, any reasonable local authority, to back down. If they, as I say, if they don't back down, then make sure you've lodged your appeal in time, which is in 2 months minus a day of the decision, because I cannot see a tribunal naming a school where the school have said they cannot meet needs. And a local authority simply can't go to tribunal. They're trying to put pressure on the school to admit, it seems to me, and you should not accept that. Unreasonable, I'm afraid. Next question, please, Emma.
Okay, so the next one is a little bit more complex. So it says, both preferred out-of-county SEN senior maintained schools have said they can't meet needs as they are full. The parent has requested to challenge this, but LA have said they think it's unlikely schools will change their minds as it's out of county. The local authority can't force them to accept my child. Is this correct? Also, my closest SEN maintained SEN secondary school has said they could meet need, but they are full. Can the LA challenge this?
Right. If it does depend. There are various types of schools, and I dealt with them briefly at the beginning. If it is a maintained school, what I mean by that is it's maintained by the local authority. The local authority can direct a school to admit. So if you have a special school that is close, is in your county, is maintained by your local authority, and you would be content, if I put it that way, for your child or young person to go to that school, you can say to the local authority, I want you to admit. I want you to direct the school to admit my child or young person. Now, if the school still says, if the school is, and of course now you have a lot of, it's more complicated now because a lot of the special schools are now academies, and sort of, they're still state schools, but they're not, they don't have, the local authority doesn't have the control they had when they were maintained by them. So it depends on the status of the school. If it's an academy, you've got more difficulties. What I would do in your case is all of the schools are saying that they have no space. So I would choose the one you think can best meet your child's needs, and the one you would very much want your child or young person to go to. I would then lodge an appeal for that school, because it is, if it's a special school and it's not that big, it has small class sizes, I think that it's quite likely that a tribunal would admit. If you do appeal against that decision, the local authority have to name some school. So they're going to have to come up with a named school. So either it's the one in their county, which they've directed to admit or persuaded to admit, or it's an out of county. So the fact that the school that you've applied for out of county says they're full doesn't mean that you will be unsuccessful. I would decide which of the schools do you really want the most. which can best meet your child's needs, and I would lodge an appeal against that particular school. And it's going to be difficult for, although it's an out of county, that's to a certain extent it's irrelevant. If it's a special school, then it can, so if it's a special school, the class size is likely to be small. It's going to be difficult. It's going to be difficult for a local authority to defend that. It's going to be difficult for a school to say we can't take one more. There is also a sort of, some schools are approved, independent schools are approved under Section 41, but that's a bit more complex. What I would do is decide which school you want, and go for that. I mean, do look, if all of the state schools around you are said to be full, then go and look at independent special schools if there is one near you that can meet needs. Okay, next question, please.
Okay, so there's going to be some follow-up questions which I'll deal with shortly. The next one is what can be used as good evidence that no school-based placement will be able to meet needs?
That's a very good question. It's really looking at all of the the local authority are likely to come up with various school-based placements. Look at them and have your list of reasons as to why that cannot meet needs. So it can be all sorts of reasons that your young person has such severe anxiety they're not going to get into school, that your young person has such severe anxiety that any change in routine or circumstances makes them very distressed. And for example, if there's a change in routine in any way, or they become so anxious they sometimes can't even get they wouldn't be able to access education. It could be health reasons. So there can be there's not a definitive list. It depends on the circumstances of your young person or child. Next question, Emma.
Okay. The question is it not possible to have an independent school named by an LA or tribunal in an EHC plan, even if the local authority objects, unless a statutory exemption is made out if it's a Section 41 school? So this is about, obviously, where do Section 41 schools come into the fact that you can have them named?
Well, it's so going back a bit, it doesn't really matter whether it's Section 41 school. The Section 41 is just a school that's been approved by the Education Department. You can have independent schools that are not Section 41 schools and still be named by a local authority or tribunal. So go back on the question again, sorry, Emma.
So it says, is it not possible to have an independent school named by an LA?
Hang on a sec. Is it possible to have an independent school named by an LA or tribunal? Yes, it is. Yes, go on.
Even if the local authority or local authority basically objects using one of their statutory exemptions. So basically, can you force to admit a Section 41 school?
You can't. The local authority might object, but providing the school is willing to admit, you're okay. If it's an independent school, as I said at the beginning, if the independent school does not want to admit, then you can have some difficulties. But if the school is willing to admit, you can appeal for it, and you can persuade the local authority to name it, and or tribunal.
Okay, so the next question is when you have tribunals that are going ahead, and then obviously there is a phase transfer, what happens then? So the example given was that there was a tribunal last year, early last year, and obviously they were due to move phase transfer for September 2020, but the phase transfer never happened. So what happens when you link the tribunal system and the phase transfer, and you've got like a tribunal running, but you then hit phase transfer?
I'm not quite sure I fully understand the question there, because if you've got a tribunal outstanding, it might be there is a delayed phase transfer and the child might be out of education. So I think we gave an example of, let's just say the local authority does not issue an amended EHCP dealing with a phase transfer until June or July this year, and you then appeal against that decision. It may be your appeal will not be heard until January of the following year, and so your young person or child will be out of education from September. Is that have I understood the question there?
Yeah, so basically what they're trying to establish is that obviously if you have a tribunal last year in June and they didn't deal with the transition and the child was meant to move in September 2020, what happens then?
Well, I think that's bizarre that a tribunal in June 2020 didn't deal with a transfer of school September 20.
So yeah, that's the issue.
Yeah, I mean, I would have expected a tribunal to be considering a naming. So is that if that young person is out of school, then you might have to appeal again. I think that's very odd. A tribunal June 20 did not deal with the phase transfer September 20. A tribunal June 20 with a phase transfer September 21, I could see that. But if they were meant to transfer September 21, I can't quite understand why a tribunal didn't deal with it.
So the next question is another complex one. What are the current legal implications for placement in mainstream? The child has been accepted at Choice Secondary School, just coming out of homeschooling and wishing to return to his previous primary school to reduce transition anxiety and get back into routine. Schools say they are full and cannot fit another child and adult into the class. More work for class teacher, as the class already has a high number of high needs children. Staff has changed in the past year. The LA is willing to overturn their decision, but time based from now to July, it's not worth the tribunal time, etc. So the parents suggested that they continue to educate at home, but doing the schoolwork year would have been set at school. LA is currently checking legality of being on register at a mainstream school, but being educated at home. So basically, yeah, can you be registered at a school but being educated at home?
Wow, I've not come across that. That's very unusual. You're right about if that's what the school's saying, and the local authority might challenge it, but no tribunal. By the time you had a tribunal, given we're in 1st of February, you'd be lucky to get it before September, so that gets you nowhere. I'm not quite to be honest, I'm not quite sure of what the answer is, in the sense that if the child's on roll, they're entitled to education at school, although at the moment, of course, most schools, the lessons are all online. So why can't they continue to do that? Well, I guess the answer would be a teacher, whilst the lessons are online, I guess the child or young person could join in those lessons and be on roll. But once the children go back to school, and who knows if and when that's going to happen, the teacher would say it would be impossible to prepare a live lesson and, if you like, a virtual lesson. It would be simply too much work. I think that's an interesting question, and I'm not sure there's a clear answer I can give, other than to say you are right on the timing about going to a tribunal. I would say that it is going to be difficult for the child or young person to move to secondary school if they've been out of education a while, because secondary schools tend to be larger. There's a lot of moving around. They've got to kind of have all their equipment for each lesson. So it might be that it might be a case, and you may not want to think about this, but you could ask for the child to do to go in September 21 and repeat year 6. Now, if that's an option, you could consider that. So they went into school, that they were allowed to do online lessons as long as they were online. I think a school would say it would be they just couldn't manage putting online lessons if everybody was not online. But consider whether the school would agree to the young person starting September 21 to do year 6, so they'd be educated 1 year below, which would prepare them for secondary school, because if they're going to a mainstream secondary school, having been out of school a year, for some time rather, and they have anxiety, I'd be concerned about that.
Okay, so the next question is that a child has a receptive language disorder and autism. Would that mean that they would need a special school? And what happens with delaying them a year and keeping them in nursery for a year?
Okay, receptive language and autism doesn't mean they have to be in a special school. Parents have the right to ask for mainstream education, and local authorities need to make reasonable adjustments for that mainstream education. It really depends on the child and the child's difficulties. Yes, you can ask, and often children with a diagnosis of autism do benefit for having an extra year in nursery before starting reception. Not every case, but if your child has an EHCP, we haven't come on to, or indeed a statement, if you're in Wales, Section F or Section 3 of the statement sets out the provision to meet the needs of that young person. Now, if that young person has autism, and probably has sensory difficulties, I would expect there to be some direct occupational therapy in Section F or Section 3 of the statement. Receptive language difficulties, I would expect there to be some direct speech and language therapy in Section F or Section 3. But in addition, a provision in Section F can be that that child should be educated 1 year below their chronological age. And that can be what we call special needs provision in Section F. There was a case that specifically says that if you want your child who has special educational needs to be educated 1 year below the age, their chronological group, that they can. So what I would do in that case is ask the local authority, say to the local authority, you want that your child or young person be educated 1 year below chronological age. What you need to be aware of is that if your child or young person is educated, it doesn't start reception until 1 year later, probably they will forever be educated 1 year below. And you want that in the statement or EHCP throughout, because it can be quite difficult for a child or young person with special needs to suddenly go into a year which essentially they'd be missing a year of education. But you can ask for that. But you don't have to accept a special school if you want a mainstream school. Quite often, children with autism go to mainstream primary schools, certainly infants and often juniors. It can be that when you come to secondary school, it becomes more tricky, it becomes more difficult. Next question, please.
Okay, during a tribunal, must the local authority name a school? Can the local authority go to tribunal with just naming a type of school? Do they have to name a school as part of the tribunal?
They should name a school. They should name a school. I mean, they have to come up with a school placement, because if you're saying, if you as a parent want a particular school, the local authority need to identify a school, because you need to be able to say why the school the local authority is naming cannot meet needs. So I don't know whether the local authority is simply saying mainstream school. If they say mainstream school, well, mainstream schools are different. So you would want to know, how big is that mainstream? I mean, some mainstream schools are over 2,000. Some mainstream schools have 800. So is the mainstream school the local authority is suggesting, big or small? Does it have a unit, a specialised unit? Which mainstream school is the local authority suggesting does it have a specialist? What is the SEN support in there? How many young people in the school have special needs? So there are a lot of questions you want to ask. I mean, I would possibly, if that local authority is trying to do that, and you're in the middle of a tribunal process, I would ask the tribunal to force the local authority to name a particular school, because if you're going to tribunal because you want another particular school, and if the local authority is saying any special school, that's madness, because all special schools are pretty much different. They cater for different types of children or young people. That makes no sense to me. So I would be asking the tribunal to direct the local authority to name a school, because if you're going to tribunal saying I want X school, then you've got to, part of the process of the tribunal is to say, well, the local authority school cannot meet needs, therefore name mine. And how can you possibly do that when it could be in any number of schools? Next question.
The next question is, can you challenge an independent specialist college who say they can't meet need due to no wheelchair access to outside grounds? They have gravel outside and don't seem keen to change it.
That's a very interesting one. I think that is more tricky when it comes to because I already said that with independent schools they're difficult to challenge in the sense of forcing a tribunal or persuading a tribunal to name them. If it's one of disabled access, such as not having gravel or not being able to access, I'll be looking into that more closely. That may be disability discrimination, but disability discrimination is not, although I've dealt with some disability discrimination cases, I wouldn't say that I'm an up-to-date expert. So I would be, I would consider contacting one of the organisations that deals with disability discrimination to see if they can assist you on that, because I think you may need some specialist advice and help on that. That usually when you have an independent school, because they are a business, if they say they can't meet needs, then there's not a lot you can do about it. But if it's saying it can't meet needs because it can't accommodate a wheelchair outside, that to me seems to be something that I would want to obtain some advice on as to whether that would be disability discrimination. So I think that's the best I can do with that one.
Okay, so next one. The local authority have refused to name an independent special school in Section I as their own due diligence was flawed and delayed, further delaying issue of the final EHC plan. What can parents do to get the plan finalised to go to appeal? LGO already investigating time delay.
It's very common. Local authorities do not, or often do not, comply with the statutory timescales. If they haven't issued the final EHCP, then you cannot appeal to a special needs tribunal. You need them to issue the final EHCP. You can threaten them with judicial review, because they are if they've taken too long to issue the final EHCP, because you need them to issue the final EHCP, and then you can appeal. But it may be that's a situation where you might want advice on judicial review proceedings, because you can't do anything until you've got that final EHCP. Next question.
Okay, so the next one is okay, so the parent is considering a state school out of Bristol for naming in their EHC plan. Do they still continue to have their EHC plan run by Bristol local authority? If they move out of Bristol, does the EHCP transfer, or do they have to go through the whole process again with the new local authority?
Right. The short answer is, if you have an EHCP, your child or young person continues to have an EHCP if they move to another local authority. So if you live in England and you move from Middlesex to Somerset, your child continues to have an EHCP, but when you move, the local authority will carry out usually a reassessment. That depends from local authority to local authority, but if you're looking for it depends what support your young person or child is receiving, and it depends whether your child or young person is, did you say a mainstream school, Emma?
It's not special, not
No.
state school, basically. Yeah, so mainstream at the moment.
So mainstream, it may be you can persuade the new local authority to simply take over the existing EHCP, but it depending on the local authority, depends on how long it takes. So some local authorities can be quite good, that if a child moves into their area with an EHCP, they will take over the EHCP, they will make the provision. But it's like with everything, anything to do with special needs, it's a bit of a lottery depending on your local authority. But the local authority should take it over, but they usually will just look through it. So if, for example, there is something, you know, it may be, it depends when the last EHCP was reviewed and amended, and it depends what provision is in there. So a local authority, you know, may well carry out some reassessment. You don't go back to the beginning, but you do go back a few steps is probably the answer. Next question.
Okay, it looks like for the moment that's all the questions. I mean, there was a question which you can try and answer now. It's slightly a little bit off topic, but I will just go back and try and find it. It is the very interesting. It is the problem with looking through chat. Here we go. Can you claim compensation for a local authority refusing to issue a final EHC plan well outside of the 20 weeks?
Oh, interesting question. You could possibly make a complaint to the Ombudsman, but to make a complaint to the Ombudsman, you have to go through the whole local authority complaints procedure. You might get some compensation. Generally, compensation is only given where there's been huge delays. So, and it depends when the delay was. I think that if it's sort of 21, 24 weeks, 25 weeks, something like that, you might not, you might not get compensation. If it's much more than that and it's not in the middle of a pandemic, then you might do. I mean, I think that you know, some local authorities have spent 2 years issuing an EHCP, which is scandalous. But in that sort of circumstance, then you might get compensation from an ombudsman. But the ombudsman would be where you would look to get compensation from.
I have a quick question for somebody that might not be able to make the post-16 one this afternoon. Are you happy to answer it?
Yes, of course.
Okay, so it says, can you have a plan A and a plan B in a post-16 plan where one college can offer a course that the young person wants to go to, but the college won't confirm until September whether the course is being run? If not running, they say they will offer another course, but he is not interested in the other course. He is very clear what he wants to study.
Wow, I've not had that. I think that's tricky. I don't know the answer to that. That's a really, really interesting question. And I have no, I think that a plan, I mean, that's scandalous that a college won't say till September. Surely to goodness they're going to know before, because that leaves the young person in a possible situation. Well, if it comes September and they don't run the course, and that young person goes with plan B, I guess. It depends whether the local authority are with you, really. But I think that's shocking by the college. Shocking. I'm sorry, I don't really know the answer to that. If the local authorities support plan A, plan B, and we're willing to have discussions, then that's fine. You might work with it, but I don't really know how that's going to work, because if your plan B, the local authority don't like, and you then need to appeal it, you're not going to get an appeal till February. So that's tricky. Okay, is that it, Emma?
There's one more that I'm just confirming what the actual question is.
Okay.
Does the LA need to include 6K with the costs?
That's one that we have arguments with local authorities all the time about the 6,000. I argue that it's a very, very complex legal argument. I would say they don't, others say they do. So I would argue it doesn't. It's really, really complex argument. If you're within about 6K difference, then I think you should be all right. Although the 6K might make the difference. It's quite a complex argument, that one. Any other questions?
So we've got an issue whereby in order to obtain a placement, they are needing CAMS to respond to an EHC plan. The local authority are obviously withholding the placement process being finalised without CAMS. What can they do if CAMS are actually forcibly delaying the process of being able to confirm placement?
CAMS throughout this country seem to be utterly hopeless and just don't comply with anything. It's extremely frustrating. It doesn't matter where anybody is in the country, England, Wales, north, south, west, east, whatever. CAMS are very slow. I would again think about a very firm letter threatening to judicially review them possibly. It's really, really frustrating how many children's lives are being held up by CAMS. Possible judicial review there, I would say.
Okay, it looks like that is all the questions, but I'll give it a couple of minutes. So if anyone does want to ask a question, please put it in the chat. I hope we've answered all of the questions that have come up. Oh, next one. Should parents allow LA professionals to visit children in school as part of the tribunal process?
The answer is yes, because a tribunal can make an order. If you were to say no, then the local authority could obtain a tribunal order that you permit the local authority's experts to view your children in the classroom and carry out an assessment. Because if you are seeking a particular support or particular school, then the local authority is entitled to have their own experts carry out the assessment. In the same way that if you have independent experts, you can, the local, how can I put this? If you have an independent educational psychologist that you want to carry out an assessment, it can often be helpful if that educational psychologist carries out an observation in the classroom. Now, what you do find in some cases is that schools will try and prevent that independent expert going into the school. If you're in a tribunal process, you can get an order from the tribunal ordering the school and local authority to allow your independent expert to go into the school. So it's part of the same process. So if a school or local authority wants their expert to carry out an assessment, carry out an observation, you have to allow it. Well, if you can say no, but the chances are that local authority can go to a tribunal and obtain an order that says they can carry out their observation. If you but the other side to that is that if you have an independent expert and the school or local authority start to be difficult, which they often are, they might try and limit the amount of time that an expert can observe in a classroom. They shouldn't do that. Then you need to go to a tribunal and you seek an order that your independent expert can carry out the assessment without hindrance and shouldn't be time limited. Some schools are great. They understand that it's part of the process. You both are entitled to have expert evidence at the tribunal. If you think that one thing I might just say on that is that if you think that the expert evidence when you receive it from the local authority is not very good or doesn't really how can I put it, it's your child's not in that report or assessment, you think they haven't really got your child, you might want to consider submitting very short, no more than 10 minutes, video evidence of your child. So for example, in one case where it was being suggested that a child who was cognitively very bright attend a special school where the children were not, there wasn't an appropriate peer group. The children at the special school suggested by the local authority, they were cognitively at a much lower level, the parents submitted a very short video of the child talking about the child was very interested in different types of political systems and political events and was only 8, quite unusual. And so they did a video of him at home discussing this, and the tribunal could immediately see, well, this child is not going to fit into that special school. Another video evidence might be where a local authority thinks that this child or young person in a special school does not need one-to-one support or any additional support. But then you see the video of this child unable to keep on task, unable to keep on, completely distracted within a minute by anything, and clearly does need the one-to-one support. So it may be that video evidence is something to think about in some of these cases. Okay, any other questions, Emma?
With me. No, we're all done for questions, and I've just put a message up to say that we'll be finishing at 11:30, which we're on time for.
Okay, so I hope that everybody who has joined us today, thank you for joining us. Hopefully you found it useful. Those of you that know us know that in the past we have done events for parents in different locations, in Hereford, in Cornwall, in Birmingham, in Bristol, Bath, Stafford, or Birmingham. You have mentioned Birmingham. So we've done events where we call them parent information days, and we deal with a range of topics. But obviously with the pandemic, we can't do that. So and with modern technology moving all the time, and having discovered Zoom, we thought that this might be of help to parents. Particularly as some parents will be coming up to that 15th of February a deadline, and the amended EHCP, and other parents will be coming up to March 31st deadline. This afternoon we have post-16 placements, which will really follow on from this morning for those that are interested in more detail. We have recorded this, and we're hoping to put this on our Facebook page and YouTube, and we'll send out details of that. Thank you for joining us. I do hope you all found it useful, and if you did, please do comment on Facebook and Twitter. Thank you very much. Bye-bye.